Good morning, everyone. I am Mahesh. I am Assistant Professor of Law here at Sai University. And today we'll be talking a bit about the law concerning children in conflict with the law in India. All right, so let me take your attention to the slides. On the PPT, you will find a timeline of the laws and the legal developments on juvenile justice in India. And as you will see, the first point there is in the year 1850. Much like most of the other laws in India, when it comes to juvenile justice, again, it's the early set of legislations are colonial government enacted. So the very first law is the Apprentices Act of 1850, which has this provision which says that if there's someone who's been convicted of an offense and if this person is between 10 and 18 years of age, it was mandatory or it was mandated that this person be given vocational training. The idea there was that this vocational training was part of a rehabilitative exercise. Right, that's the first law. But a serious effort at trying to deal with children in conflict with the law in terms of when do you hold them accountable for a criminal act, that happens in the year 1860 with the Indian Penal Code. There are two provisions there. The first provision says that any act which is an offense but is committed by someone who is less than 7 years of age, that's considered as not a criminal act at all. So it's excused. The idea being that someone who's below 7 years of age lacks the maturity and lacks the development to have the criminal intent that is required to hold him guilty of a crime. The second thing, which is more curious, it says if it's someone between 7 and 12 years of age, you have to make an assessment of maturity. And let me read out the language of the law. It says you need to see whether the person has sufficient maturity of understanding to judge of the nature and consequences of the conduct on that occasion. Those of you who are familiar with criminal law would have immediately felt that it sounds very familiar with another aspect of criminal law, another very popular defense, the insanity defense. The first limb of the McNaughton test was whether the person has the ability to understand the nature and consequences of the act that he's doing, right? So you see a very similar language being adopted by the statute here, where it says the court has to see whether this person who is between 7 and 12 years of age, is he mature enough to understand the nature and consequences of this act, which is a criminal act that he is found to have done or accused of having done. And if the court concludes that he is mature enough, only then he is tried and convicted, right? That's the second development. And then for a long period of time, we find very little happening, except once again in 1897, where there's something called the Reformatory Schools Act, which comes up with this category of people called as a youthful offender. A youthful offender is anyone who was under 15 years of age. And if a youthful offender is before the court, they could potentially be sent to a reformatory school if in the judgment of the court by which he is sentenced, he is a proper person who can be made an inmate of such a school. Now there again, the law expects the court to make a judgment about what is the reformatory potential within this person, but only if he is below 15 years of age. Silence for a long period of time. In 1920, you have the Indian Jails Committee. Now that primarily dealt with adult prisons, but nevertheless it also had a small section on what about child and juvenile offenders. And they made a set of recommendations which suggested that we need to take them away from the criminal justice system and we need to focus on reformation. There's no point in housing them in jails, there's no point in probably even these reformatory schools, but we need to have a radically different criminal justice system, one that focuses on reformation for these children. Now as a consequence of that, in the period between 1920 and 1924, you find a lot of these provincial enactments. Tamil Nadu, you had Bombay, you had Maharashtra, you had Goa. All these states had their own children's acts. And in 1960, a central enactment was made for the union territories, and also with the idea that this will serve as a model enactment for all the other states. But no one really cared. The Children's Act of 1960 applied only to the union territories. It made this distinction between boys and girls for age, but no one really updated their children's laws on the basis of that. And that's when a journalist by the name Sheila Barse, I'm sure all lawyers and law students are really familiar with that name. She has done more than one interesting PILs. She filed a PIL in the Supreme Court pointing out that, now look, there are different states with different children's acts, and there are different ages that are being prescribed, not just for boys and girls, but radically different age between these states. So in Goa, someone below 18 was a child, but in Madras, someone below 15 was a child. Go to another state, let's say state X, and someone below 17 is a child. So there wasn't a uniformity of treatment in the country. So Sheila Barsey appraised the Supreme Court saying that this is not right and we need to have a uniform age for a child. And there was this prod from the Supreme Court, which then resulted in the enactment of the Juvenile Justice Act of 1986. That was a central law, so which means it applied to all of India, and it said all persons below 16, if that's a boy, is a child, and below 18 for a girl is a child. And this became the overarching legislation, and it was quite radical for its times, right? For one thing, you have a special set of bodies, a children's court which would try these children. So before this, it wasn't again uniform. There were some states which had children's courts, some others just used a regular magistrate's court and called it a child-friendly proceeding and tried children there. So all these dispersions in practices, diversity in practices were thrown out, and you just had one central enactment by the name Juvenile Justice Act of 1986, which applied to all of India, and all children who were in conflict with law had to be dealt with under this legislation. This held fort for another long 14 years. In the year 2000, we amended this law. Well, we left most of the administrative structures and the institutions in largely in the same shape. Little bit of changes here and there. But very importantly, it brought about a uniform definition. Irrespective of whether you are a boy or a girl, below 18 was a child. So that's the underlying thing that happened in the Juvenile Justice Act of 2000. Now let's try and recap what has happened from 1815 to 2000. You see this tendency that there is a transition towards a uniform age all over the country, uniform age across genders. That's the first transition. The second transition is to move towards a system that focuses on the child and not on the crime. Right? You take the focus away from what the crime was or how serious the crime was or what the offense was, and just focus on whether the person was a child or not. And thirdly, you also see this movement away from making any kind of assessment of maturity. 1860, the penal code said 7 to 12 years, let's judge whether this person is mature enough. And from there through 1960s, through 1986, in the year 2000, we are not going to do that. We are only going to look at age as a marker. If it's below 18, that's it. You treat that person as a child and put that person through a different criminal justice system only for the purpose of reformation. In the year 2012, something else happened, which was the Nirbhaya Incident. So in 2012, December, I don't think I need to explain what the Nirbhaya Incident is. It led to massive protests all around the country. And one of the things that came out in the newspapers was how there was a person, a child who was about 16 or 17 who was involved in that incident as one of the accused persons, right? And newspapers told us that he was the most cruelest person and he was very active in it. The funny thing being that later on the investigating officers came before the media and said that all of that is untrue. But that's besides the point. But at that point of time, there was this, I would say that there was this demand for blood. There was this very shrill demand that we need to start treating adolescents differently from children. That if it's someone who's mature enough, we should treat that person as an adult and try him and punish him as an adult. So there was so much of demand in that direction, so much of noise around that, and the government responded with the Juvenile Justice Act of 2015. Now you compare JJ Act of 2000 and 2015, it's largely the same in terms of institutional structures, in terms of how you treat children, all of that, it's largely the same. But a key difference was in you started making a division of or differential treatment based on age and the offense that was committed. So for one thing, the Juvenile Justice Act of 2015 made 3 categories of offenses. So if you just look at the slide right now, you'll see that the categorization is based entirely on what is the quantum of punishment, right? If it's a heinous offense, that's an offense for which there is a minimum mandatory imprisonment of 7 years, That's one category of offense. Something for which the punishment was between 3 and 7 years is called a serious offense. And something for which the punishment is less than 3 years is called a petty offense. So that's the first categorization. The second categorization was on the basis of age. Well, on one hand, the law said that everyone who is below 18 years of age is a child. But then when it came to adolescents, that's people who are between 16 and 18 years of age when the crime was committed, and that person who has committed a heinous offense, we are going to have a different treatment for him. The law now contemplated that if it's someone who is between 16 and 18 and has done a heinous offense, they will be subjected to something called as a preliminary assessment. Now, if you look at the slide, I've extracted section 15 of the JJ Act for you. And look at the themes that's coming in. It says a preliminary assessment needs to be done for the purpose of assessing their mental and physical capacity to commit such a crime, for the purpose of assessing their ability to understand the consequences of the offense, and also to determine what were the circumstances in which the offense was committed. And if at the end of this preliminary assessment, if the court concludes that he has the capacity to commit the offense and the circumstances are not palatable to the judge probably, he will be transferred to an adult criminal justice system, a regular court where he would be tried just like an adult, of course in a child-friendly manner. All right. Now the funny thing is, even after the preliminary assessment and an adult trial, the orders that the Children's Court can pass are either what the JJB may pass, so all your reformative set of orders, but then there's an additional option that you can intern that person in a reformative institution till the time the person turns 21. And at 21, once again an assessment is made. Has this person reformed sufficiently? And if the court concludes that the reformation is inadequate, he or she can be transferred to a jail, to a regular adult prison. So this is the big change that Juvenile Justice Act 2015 has brought back, right? The potential or the possibility that someone who was a young offender can actually land up in jail after 21 if the assessment is that the person has not reformed sufficiently. All right. So if you take a look at this once again, you see a lot of transitions. For one thing, we seem to have moved once again away from the idea of uniform age, that all persons below 18 were just treated as children, and then irrespective of what their specific age is, they are treated as children and tried as children. From that, we've built a new category now, 16 to 18. The second transition is we seem to have brought the focus back on the crime. So earlier it did not matter what the offense was. Irrespective of what the offense was, all of them were to be tried before the Juvenile Justice Board. But now we've seemed to put crime back into the picture. If it's a heinous offense, it's a different treatment. And more importantly, you see this going back into assessment of maturity. So it's pretty early on, only in the 1850s and probably somewhere till about 1920s, that it was thought that we will make some kind of an assessment of how mature the person is. But then in 2015, we've just gone back to that system to look at how mature a person is for the purpose of treating him differently as an adult. Now, there's been a lot of criticisms against this. Most principally, we've come across writing by Professor Ved Kumari and Swakata Raha, who've put forth a lot of doctrinal criticisms. They've pointed out that probably this is not in the best interest of children. It is of suspect constitutionality. The classification is not a reasonable one. Definitely the system does not meet the objectives of the Child Rights Convention, and then it probably violates the Child Rights Convention itself. So those are the principal set of criticisms that both Swakata and Professor Ved Kumari has raised. But I have a couple of functional issues to point out. The first question to ask is, how are we going to assess capacity, especially mental capacity to commit a crime? Is there any standardized methods for this? The law does not provide us any guidance. And I've had the privilege of looking at some of these assessment reports. Many of them are just blank. They just say that there's a line which says that I have examined the child and I have concluded that the person is sufficiently mature. But How was this conclusion arrived at? There really isn't any method, any standardization that's available for assessing this maturity, and you find a diversity of practices. In some places, they do an IQ test. Well, an IQ test is not really a maturity assessment, right? It's just an intelligence quotient test. It does not assess someone's maturity. But that's what many psychiatrists have been doing in many places. And if you ask them, why are you doing this? Well, they say, what else do we do? There is no tool available with us for the purpose of assessing maturity. Now, when it comes to courts of law, there's at least one Bombay High Court judgment which refers to a United States case. It's called United States versus Kent, which is a case about, again, waivers. That's what they call these transfer systems, waivers. And in that judgment, the Supreme Court had laid down a set of criteria for the purpose of deciding whether to make a waiver or not. And the Bombay High Court thinks that we can pretty much draw on this. Now, the problem is, United States versus Kent was decided in a very different context. It was only in the context of assessing whether a person is mature enough to stand trial, not for the purpose of assessing whether someone was mature enough to commit a crime. They're two different things. So the United States versus Kent precedent decided a very different context, and so you're picking up that same case law and applying it here. Probably that's inappropriate. Well, and the second and the last issue that I'd like to ask is this question of, let's look at what is the actual time that's taken to complete proceedings in India. I invite you to take a look at the slides once again. There aren't many studies, or that we don't have solid enough data in India to tell us how long it's taking for the boards to decide cases, but at least two studies, one from Assam and one from Bengal. You can see the breakup of pendency there, and you'll see that in Bengal, more than 50% of all the cases have been pending for more than 3 years. In Assam, the figure was, something in excess of about 25%. So let's imagine a situation where someone who is about 17 and a half commits a heinous offense, completes preliminary assessment, moves to trial, and it's going to take 3 years or 4 years before the trial finishes. The person is already 21. Now, how are you going to assess that person's maturity? How are you going to assess whether that person has been reform sufficient when we've not even given a chance for it? All right. And lastly, the bigger question to ask is, the law says to conduct preliminary assessment, the board may take the help of qualified psychiatrists or psychologists or social workers or psychosocial experts. Where are the experts? This is one country where we do not have sufficient number of mental health professionals available. We don't have enough psychiatrists to cater to the needs of this country. You will not find a psychiatrist in every district in this country. And so how are the boards going to take serious professional help for the purpose of conducting these assessments? So the bottom line is, we seem to have made this reactive change. 2012, Nirbhaya happens, and there's a lot of protests. There's also a demand for retribution. There's a demand to draw blood. And immediately we change the law, and we change it in a direction such that we are going back to what we were doing in the 1850s. So the question to ask, the things for us to discuss is this an inherently arbitrary procedure? And how do we really balance the rights of a child offender and those of a victim of a serious offense? Because that's where this really stems from, right? So that's the second thing for us to discuss. And thirdly, how do we deal with this societal pressure that calls for more blood when it comes to children who have committed crimes, right? So this is what we can discuss further.